listening to Real Estate Insiders Radio, featuring successful real estate insiders, influencers, and trendsetters sharing proven tips and strategies to help you navigate the complex world of real estate right now.
Welcome to today's show. I have here with us Jesse Hamilton, who has a JD from Gonzaga University, go Bulldogs, where he received cum laude distinction. And he also has a Bachelor of Arts from University of Washington, Huskies. So kind of an interesting mix there between a Husky and a Bulldog. Isn't there a joke about that?
Yeah, some kind of a crossbreed.
Yeah. Or maybe that was the Shih Tzu from, but Mr. Hamilton here is a current Senior Vice President, General Counsel for Pioneer Title Companies in Washington, Idaho, and Wyoming. And prior to moving into the title industry, he practiced law in the private sector, focusing primarily on business and real estate transactions and a little bit of litigation in there. Mr. Hamilton is licensed to practice in Idaho and Wyoming, even though he went to law school and University in Washington.
Yeah, that's right. Expanding my horizon.
So he's a distinguished guest here, former 40 under 40 guy back even a while ago. It looks like he could still be on there, but welcome, Mr. Jesse Hamilton.
Well, Max, good to be here. Appreciate it.
Yeah, so basically, what I was thinking is it would be a really fun time to talk a little bit about 1031 exchange. You know, there's been a little bit of talk about it in the media lately, and it certainly has a long history here in the United States. And so maybe you could kind of start out and tell us a little bit about the history of 1031.
Well, 1031 exchanges per se have only been around since about 1990. That's when that section of the code was codified. Prior to that, it was a different section of the code called Section 112. But by and large, and for all intents and purposes, exchanges in general have been around since about 1921. I mean, we started with the Revenue Act in 1918 to pay for the Great World War, and soon thereafter you start seeing use of the language like kind as early as 1921. So Section 1031 is what we refer to it today, but a like-kind exchange in general has been around for decades, and it's been very infrequently affected by tax reform.
And like-kind is an interesting terminology that you hear a lot in 1031 exchange, and so would you maybe talk to us about some of the court's cases and how the IRS looks at a like-kind exchange?
Sure. I think in that regard, it's always important to, think of it in silos. So you have real property, which is real estate. It's, a bundle of sticks. It's fee title ownership. And then you have personal property, which is everything else. With regard to real property, the term like-kind is construed broadly. Basically, if it's conveyed by way of a deed, or if it's considered an interest in real property by any given state's law, then it's going to qualify for Section 1031 exchange treatment. When you get into personal property, it's a little bit different. The term like kind is a little more restrictive, and if you're selling a dump truck, you have to exchange into another dump truck. So it's a like kind or a like class item of personal property. But you see both. I mean, real property is used the majority of the time, but there are certainly a lot of personal property exchanges that go on around the country.
Now, in real estate, though, let's say a farmer sells a piece of ground. We were actually talking to a farmer recently, and let's say they sell a piece of ground, some acreage, and then they pocket a big chunk of money, and that person's transition to retirement may include, purchasing some apartment complexes, purchasing a commercial building, things of that nature, so they could actually move the equity from the farm into other real estate assets. And so would you say it's the case that it's allowable to exchange a farm in Idaho for a commercial property in Florida, or a apartment complex in Hawaii, or a piece of land in California, so long as it's for investment purposes?
Yeah, and that's the key, Max, is really it needs to be, when you're dealing with real property, it needs to be for trade or business purposes or investment property. And what I tell clients when they ask what can they exchange out of and into, the simple answer is any trade or business or investment property, period. The best way to look at it is it's every type of real property other than a primary residence or a second home. So if you currently use it as a primary residence or a second home and there's no rental activity on it, in my opinion, it would be unwise to do a 1031 exchange and try to declare it as investment property when historically it hasn't been used in that manner. Likewise, when you buy a replacement property, you need to purchase it with the intent that it be held for investment purposes or to be used in a trade or business. So back to your general question of, can you sell ag property and exchange into commercial or industrial or office? And the answer to all that is yes, because those are all examples of trade or business or investment property. We have a number of clients that sell agricultural property, and that's kind of a liquidation event in their life. And it would be wise for them to diversify a little bit. And so they do tend to put some of the proceeds into a 1031 exchange to buy income producing property to help them continue to live. Yeah.
Or even increase their stream of income. If you're able to get one investment property that provides a 4% cap rate, say it's $1 million, you're getting $40,000 a year. If you can exchange it and get it into something that's a 7% cap rate, then you're, generating $70,000 a year. Or $1 million would be, yeah.
Yeah, absolutely. I mean, the whole premise behind a 1031 exchange is you're not putting yourself in a better tax position. You're in the same tax position you were in before. You just own a different asset, and you hope that it's a better asset than what you had before. It has better income generation. It has less deferred maintenance, whatever the case may be.
Yeah. Or something. Yeah. Or maintenance. You're moving to a farm, to an apartment complex. You're getting ready to retire. Now you want to live off of the income instead of continuing to invest.
Absolutely.
So what about timelines? There's some interesting timelines that come with 1031 exchange. Can you tell us a little bit about those?
You bet. The timelines are kind of the easy part. They're hard and fast. The entire shelf life of a 1031 exchange that is within the safe harbor of Section 1031 of the Internal Revenue Code gives you 180 calendar days. So, upon the sale or disposition of a property, where it funds and records. That's what we're talking about, the movement of money and the recording of a deed.
And that recording starts the clock for ticking.
That's correct.
Okay.
And from that point, looking forward, you have 180 calendar days. So it's not like filing for your taxes where if the 180th day falls on a weekend or a holiday, you have until the next business day. In theory, if it falls on a Saturday or Sunday, I'm sure that you could find a title company willing to sign the parties over the weekend, but you're not going to find a bank or a county recorder that's going to be open to fund it or to record it. So
don't wait until day 178 to close. You may want to try and close by 160 or something like that so you can relax with a cocktail in your hand.
Absolutely. So that's the first time frame that needs to be met, is the 180-day deadline. And then within the 180 days, you have 45 days to identify suitable replacement property. And that the identification process is done really just between the taxpayer, the person doing the exchange, and the accommodator or the qualified intermediary that they're using for the exchange. And there's a form that the taxpayer needs to fill out and submit to the accommodator by midnight of the 45th day that reasonably identifies, one or two or several replacement properties that they're interested in.
Okay, and tell us why this is such a crucial deadline and how that can change an investor's outlook on the transaction.
Yeah, the 45 days, a lot of people don't like it because it's not a long time period to find something. I mean, if you're selling a sizable asset and you put an exchange in place at the last minute, you literally have 45 days to shop and something might not present itself. So we oftentimes have clients that struggle with the 45-day identification period. And the importance of it is because the IRS says it's important. They say that you basically only have 45 days to identify. And so, where I work, we kind of follow the letter of the law, and the expectation is, and the requirement is that, the identification form be submitted by midnight of the 45th day. Now, within the 45 days, you can change your mind as much as you'd like. If you want to submit a form on day 10, and then you change your mind and you constantly tweak it, every few days, that's fine. But whatever the last document, the last identification form that we have on file on midnight of the 45th day is what we're going to work off of in order to make sure that you have a valid 1031 exchange moving forward.
Well, and this is very important because let's say that I identify a property at the 45th day, and then afterwards on the 48th day, I decide that I really don't like something about it. I've discovered some new type of a problem or something like that. Then will any leniency be shown to give me an additional extension, or is it just...
There shouldn't be any leniency. I mean, the deadlines are kind of hard and fast, both the 45 and the 180. So you can certainly ask for an extension from the IRS to re-identify, but I sincerely doubt one would be granted. That's why we stress to our clients the need to identify a couple of fallback properties. So you identify your favorite as well as your second and third favorite. You use the identification rules to your advantage to identify as many properties as you can. So in the event something doesn't pass inspection or appraisal or whatever the case may be, you have some other fallback properties that you can still pursue.
So in the event you find some depleted uranium on your property and it's going to be extraordinarily expensive to clean up, you can move over to another property. But it also brings an interesting issue for a lot of brokers. You do have to disclose, there's a disclosure requirement to say that you're in a 1031 exchange, and the seller on that property may know that they have a little bit of leverage because that buyer is motivated by some kind of tax savings. And so sometimes that information could be, would you say, advantageous for the seller in negotiating with the buyer?
Yeah, on the one hand, I always like transparency in contracts, so that if a buyer, once when a seller then becomes a buyer through a 1031 exchange and they're looking to acquire replacement property, by notifying all the parties and then just having a general cooperation clause that, the buyer intends to complete a 1031 exchange. But as to the seller, there's no additional cost, expense, or liability to the seller. That's great. Sure. But I have had brokers tell me that, if this is a tightly negotiated transaction, they don't necessarily want to disclose that initially. And in which case I would tell the broker working that file that, well, okay, then go ahead and don't have the cooperation language about the exchange in the contract, but by all means make sure that the contract is assignable. Because what needs to happen, what happens in an exchange when you back up and we're dealing with a seller, when they sell, the accommodator takes an assignment of the seller's rights in the purchase and sale agreement, which is really the right to receive proceeds. So the accommodator receives the proceeds, holds those in trust, and then when the taxpayer, the client, goes to buy a replacement property, we need to make sure that that contract can be assigned to the qualified intermediary for the sole and limited purpose of completing a 1031 exchange, which really means just moving the money for the seller's benefit into that property. So there are some options around disclosing, having that initial disclosure with the seller and giving them any kind of negotiating leverage. You don't have to mention it. Just make sure that the contract can be assigned.
Well, and as a broker, you owe your clients a duty of confidentiality. So while there is a requirement to disclose that it's subject to 1031 exchange, you don't necessarily have to disclose that, hey, the first two transactions fell apart and this one has to work. There's no other options at this. That could be kind of a distinction on something that's confidential information versus, hey, they're doing a 1031 exchange.
Sure. I mean, you kind of play the field and let them lead to believe that maybe there's a couple of other properties that you're negotiating on, and this is just one of them. How the broker proceeds with that is, I guess, that's personal opinion.
Yeah. Okay. And how about, let's talk about the difference between tax deferral and tax savings.
Absolutely.
So this is an interesting one. Do you have some things you can tell us on that?
Yeah. I do a lot of teaching on 1031 exchanges, and one of the biggest lessons I try to stress to people is we're talking tax deferral, which by definition, deferral just means putting off to a later date. So, earlier I alluded to the fact that we still have the same tax liability we had in the old property. We're just in a different property. So by definition, all we're doing is taking our our adjusted basis in the old property or the relinquished property, and we're shifting it over to the replacement property or the new property. In doing so, if we buy a property of equal or greater value with equal or greater debt, and we reinvest 100% of our net proceeds from the sale, then we have deferred all of our capital gain as well as any depreciation recapture. So again, your basis in the new property is the same as what it was in the old property. We're just in a new property. So by definition, that's the benefit of a tax deferred exchange is you're not having to recognize gain and pay tax on it. You're kicking the can down the road. The real benefit in the exchange is, if you do exchanges your whole life, upon your death, all that deferred gain and deferred recapture actually ceases to exist. It's forgiven. So you can kind of kick the can down the road, and then when you die, you win. You just have to die to get
depending on what the estate tax is at the time.
Well, you might have an estate tax to worry about, certainly. But that's the benefit of the exchange. A lot of people get it confused with Section 121 of the tax code, which deals with the sale of a primary residence, where you're actually excluding a certain amount of gain from the sale. $250,000 if single, $500,000 if married. We've all heard that mantra, but a lot of people kind of blur the lines and think that, I get this $250,000 or $500,000 exclusion when I sell a rental, and that's not at all true.
Yep, because the rental is an actual investment property, so it's taxed differently than a personal property. You said something in there too that was interesting, as you were talking about deferring both the capital gain and the depreciation. And so, just so listeners have some understanding there, let's say you buy a property for $1 million. And you hold the property for 20 years, and say it's a residential income property. So you've depreciated 20 out of roughly 27 and a half years.
Yep.
You've depreciated it down quite a bit. That's now your basis. So it's not only that I bought it for $1 million and I sold it for $2 million. So not only do you owe the $1 million for the capital gain, you also are going to owe money on depreciation recapture, so that you've depreciated it from $1 million down to $200,000. So you have an $800,000 depreciation recapture potentially and a cap gain. So I just want to allude, I'm not an accountant, I'm a real estate broker, but I want to show that there is a distinction between the capital gain and the depreciation or depreciation recapture.
Yeah. And a lot of our kind of institutional commercial real estate investors do exchanges not to defer gain, because they might not have a sizable gain in the property, but they do have accumulated depreciation. So in your example, on $1 million building, let's go back and say you buy it for $1 million, and upon acquisition you allocate $100,000 towards the dirt. Okay, the actual lot
that's
cost.
The land value,
which can't be depreciated.
Yep, that's okay.
And so then we have $900,000 that is a depreciable asset, and
which is the building value.
Yeah. So you're right on it. Assuming that this is a residential, like 4 units or less, then you have a 27.5-year depreciation schedule. So using rough numbers, over the course of 20 years, you've depreciated over $600,000 in value. And there's a huge benefit to that, because that shelters income. So you've had this wonderful dollar for dollar offset of depreciation to offset income. But upon the sale or disposition, if you don't do an exchange, not only will you pay tax on your gain, and we'll get to that, but you're also going to pay a 25% recapture rate on what you've depreciated. So if you have $600,000 of depreciation, that's what, $150,000 tax bill on your recapture. And then if you bought it for $1 million, that's your original basis, and then you sell it for $2 million, the difference between your all-in cost and your sales price is your capital gain. So then you have $1 million of gain that you'll pay a varying rate. It kind of depends what the state rate is.
Sure.
But by and large, you're probably looking at between 20 to 25% on your capital gain as well.
So and if you're in California and upper income, higher maybe, and a lot of this depends on your accountant, and not your accountant, but the tax laws and the jurisdiction that you are in.
Correct. You're going to pay a federal rate, and it's anywhere from, generally speaking, it's 15% for most taxpayers, but if you're an exceptionally high earner with $1 million of adjusted gross in that year or more, you're going to pay 20% on your, and that's just the federal rate. And then there are varying state rates in addition to that. So yeah, coming out of California, it can be, it can be crowding 30%.
Yep. But we shouldn't forget too, we've been talking a little bit about the depreciation recapture, and it kind of makes it sound scary, but one of the really nice things about investing in real estate is that you can actually depreciate the property. And so when we go back to our $1 million example with a $900,000 building value, if you did that over a 27.5-year depreciation schedule on a flat line, you're looking at $32,727 per year that you're writing off. So for those first 15, 20 years or whatever the term is that you own the asset, you're getting a sizable write-off through depreciation. It's just that you have to pay the piper at the end, right?
Yeah, I mean, it's a huge benefit. Absolutely. It's one of the benefits of owning real estate, and income-producing real estate is depreciation and being able to offset income with depreciation. So, a $32,000 depreciation allowance a year literally shelters $32,000 of income. It's money that you receive, but you can protect with your depreciation allowance. And then, if and when you sell the asset, and if and when you choose not to do an exchange, your worst case scenario is you have to pay back 25 cents on the dollar, which is not a bad loan repayment program.
Yep. And so in a nutshell, would you say that it's pretty fair to say that the reason that 1031 exchange is so attractive is that in investment property, you could make a substantial capital gain, and you could also readjust your depreciation schedule so that you could be in a more favorable tax position and exchange the type of real estate that you have. So you can get out of one type of real estate class and into another real estate class that may be more compatible with your situation in life. If you're retiring, maybe you want something more stable. If you're younger, kind of as in equities, maybe you're willing to take a little more risk, and it is something that allows you to move across assets without paying, massive taxes. That if you were purchasing Google on the New York Stock Exchange and, selling it and making $1 million gain, you're gonna pay the entire cap gain, right?
Yeah.
You're not gonna.
There's some other securities laws that can be beneficial, but we won't. I'm probably not the right guy to talk on that. But generally speaking, real estate, most wealthy individuals have some percentage of their investment portfolio that's held in real estate, and when they sell it, instead of electing to pay the tax, the downside of not doing an exchange is you're paying tax, which means you're decreasing net worth.
Yep.
Okay. The positive of it is you're paying tax, and so that your after tax money you can do with as you please. Yep. You don't have to buy more real estate. You could wait and invest in a business, or loan it to your children, give it to your children.
Yep.
You buy securities, do whatever you want. But the benefit of an exchange is we're maintaining a higher net worth, and we're using that money, the money that we would otherwise have to pay to the government. They're allowing us to use it to reinvest in real estate only, in investment property or trade or business property only. So you are limited in what you can do with it, but it's an interest-free loan from Uncle Sam. The tax, the check you would otherwise have to write, you can elect not to pay it so long as you follow the rules and buy a replacement property that qualifies. And and the hope is that you put yourself in a better property than the one you were in before. And if that means diversification or changing real estate asset classes, that's what it means. Exchanges and what works for people, I found over the last 15 years, is incredibly subjective. And I do not get involved in people's property selection choices. I tell them, don't let the tail wag the dog. So the purpose here is to defer tax if you can find a replacement property that checks off all the boxes. Your worst case scenario is you enter into an exchange with a good faith intent to buy a replacement property, and something doesn't present itself, and you don't feel comfortable with what's available at the time, so you allow the exchange to fail. And then you ultimately end up paying the tax you were hoping to avoid. But there's no penalties for that.
But you would have had to pay the taxes anyways. So you're just
Sure.
you're just paying the taxes, and then you're resetting the basis for your dollars.
Exactly right.
So yeah, it's so can you tell us a couple interesting story? I know that you probably have about 500 interesting real estate stories. I'd love to buy you a coffee or beer and just hear about 20 of them. But can you tell us one interesting one, that kind of pertains to 1031 exchange?
Yeah, I mean, in terms of interesting, I always like success stories. Exchanges done right. We have clients that they do struggle with the 45-day identification period. They come back on day 60 and say, pretty please, can we re-identify, just disregard that other one and let's backdate the new one. And, those are things
you can't do.
Well, no. And my company doesn't do it. And, all the accommodators out there shouldn't be doing that. I can't speak for them. But on the success side, where I've seen exchanges work really, really well, particularly in agricultural-based states like where we are in Idaho, is if you have, mom and pop own an 80-acre farm, but it's now surrounded by rooftops. I mean, they're in the path of growth, and their development land, their ag land, for ag pricing is worth X, but they decide to sell. There's just too many people around here. We want to move a little bit further out. We want to liquidate, whatever the case may be. A broker doing things the right way can sit down with them and recognize that, okay, for, ag value, this farm is worth X, but that's not the highest and best use. The highest and best use is going to be for development, whether it's residential or commercial.
Yep.
So it's a matter of doing some pre-planning to entitle the property. Now, I'm not saying develop it. I'm just saying you get the zoning change so that you qualify for, residential development, 4 rooftops per acre, whatever the density allows. In doing that, mom and pop still have a farm. They're still farming it.
Yep.
It's still an 80-acre meets and bounds legally described parcel.
And this is maybe a year or two before they're getting ready to sell. We have one of these right now where someone has some acreage and the sewer line is almost there, which, they have 70 acres. And as you know, sewer line a lot of time is the lifeblood of development. So how could just a normal mom and pop, a farmer or something, put themselves into a better financial situation by kind of thinking this opportunity through?
Yeah. So, I mean, if they just sell it as is, it's going to be for ag value and whatever that might be. It depends on,
say, 40 grand an acre or 50, 60 grand an acre.
Yeah, for ag, a lot less than that, probably between 4 to 12,000 an acre, depending on water rights and productivity and stuff. But I think what you're getting at is, the price per acre for residential development could be significantly more. So once mom and pop have the entitlements done, or they've created a preliminary plat, that's really what we're talking about. And that just requires a little bit of survey work and some civil engineering, but it's all done on paper. The land is still farm ground. Mom and pop are still farming it. They're very much still farmers, which means they're using that property in the trader business of farming. But by getting preliminary plat approval, they can then approach a developer and say, we have this 70 or 80 acres and, it's approved for a 240 lot subdivision, which enhances the value dramatically. It can be 40 an acre, in the right area in Idaho, it could be 120 an acre. And so they've dramatically enhanced the value of that property. And by doing so, they're still farmers. They're not developers. They haven't moved any dirt. They're not putting in the infrastructure. That's what the developer does. So mom and pop can then sell that asset for a significant amount of money and use the proceeds to really diversify and buy income producing property that's going to provide them the lifestyle that they want in their golden years.
Yeah, that's a great point there. And, another thing I wanted to add on to it too, that's so nice if this hypothetical farmer was being proactive about it, is when they're getting the entitlements to the property, okay, the road's going to go here and it's going to be McMansionville over here. Well, they could start to set up the landscaping alongside the road or do plans like that. So if they want to keep the house and just keep the original farmhouse to live in there and sell the acreage, not only are they getting more money by doing some of that preliminary legwork, but now maybe they have a better setting because they've decided that the road goes on the end of the property, and between that road and them, they're going to plant a series of poplar trees or something for a buffer. So really down to a lot of things in real estate, planning ahead, it sounds like, makes sense in 1031 exchange.
It does. And you bring up a great point in that, if mom and pop want to keep their farmhouse, that's one scenario.
Mm-hmm.
And you're right. They can do things to, create a more aesthetic break between their home and, the farm ground that they've always looked at over the expanse of southern Idaho. And now they're going to look over rooftops. And a lot of people don't want to see that.
Mm-hmm.
In the situation where mom and pop want to move out of the area because, they're a lot of times selling a farm's kind of like cutting off an arm for the ag people out there. But
some of these people, maybe their rights in the farm go back to the original homesteaders in the Western United States. I mean, I had a great-great-grandfather who homesteaded out in Homedale, Idaho, and so I know there's a lot of others out there like that.
Yeah, a lot of the farms throughout the country really are generational. But in the event somebody wants to sell their farmhouse in addition to their cropland or their ag property, that's where an agent can also be really proactive in trying to maximize the Section 121 exclusion that we had talked about. So when you're selling your primary residence, what you can do is do some kind of a broker's price opinion or a market analysis and look at that house and whatever it's assessed at. So let's say it's assessed, an acre. In Idaho, it's going to be a house, and 1 acre is going to be assessed differently than the 79 acres of ag property because it's going to have an ag exemption on it. So you look at that house in 1 acre and decide, what's that worth in this market? If I disregard the 79 acres around it, I just take that house and an acre in this area, what is it possibly worth? And you want to try to maximize value. So you want to use the high end of fair market value, but you need to be reasonable. But whatever value you allocate for that home, when closing occurs, those proceeds go to mom and pop because it's the sale of their primary residence. And those are tax-free dollars.
Yep.
They're excluding the gain on it. And then you really only 1031 exchange the balance or what's necessary. And in all honesty, when I deal with my farming clients and they're selling sizable assets, it's not always smart to roll all of it back into real estate. If you're selling a $10 million farm and that's really all you have, I don't necessarily think it's a great idea to go buy $9.5 million of real property. That's where you bring in a financial advisor and you kind of diversify. You exchange certainly some of it because there's still tax deferral benefit there, but you might want to recognize some gain and use those proceeds and put them in a safe place. And it's kind of the rainy day fund, or, you put those in bonds or T-bills or cash, whatever you want.
Yeah. So if you can take as a married couple a $500,000 gain, or as a single person, $250,000, you may want to meet with an accountant and your real estate broker and talk to him. How do we set this up? If the house an acre is only worth $330,000, maybe we want to sell it as a 10-acre piece so we can get the value up to make it a $500,000 gain. So that cash comes in and people could put it into a money market or something else tax-free. So that may not make them so lopsided heavy on real estate. They could get into some other asset classes with that $500,000 tax-free if it was on the sale of their primary home. So
absolutely. I mean, the IRS intends those funds to be used to buy your next residence, wherever that might be. But that doesn't have to be the case. Somebody wants to buy a motor home and travel the country, then they're free to do it.
Or a boat, maybe.
Or a boat, big boat.
Yeah, both of those sound pretty fun.
Enough money, you could even call it a yacht.
Let's see here. I'm not 100% sure where we are on time, but maybe do you mind kind of telling us about the difference between judicial or non-judicial foreclosure?
Sure.
That's kind of an awkward segue there.
Yeah.
I just totally moved the topics, but I know you have expertise in that, and I know. So you're here in Idaho, which is a non-judicial state, but then you have states like Florida, which are judicial foreclosure states, and then they've say over a certain acreage, you may still have judicial foreclosure even in the non-judicial states. So maybe you can kind of go on that.
You bet.
Little tangent.
From a 30,000-foot view, judicial foreclosure simply means that it is foreclosed through the court process. So it's very much it's a lawsuit, it's litigation. So the beneficiary of a promissory note secured by a mortgage, if you default for whatever reason, then their recourse is to basically sue you in court and obtain a decree of foreclosure, and then hold a sheriff's sale, and then ultimately foreclose out not only the owner's interest, but all junior lien holders against the property. In a lot of states, when you have to foreclose judicially, there's also a redemptive period that comes into play. So even upon the sheriff's sale or the public auction occurring, the debtors and all junior lien holders still have redemptive rights. They have the right to come and basically pay you off what you're owed, plus the judgment rate of interest. So it makes it difficult for a lot of lenders to turn those properties through their real estate owned disposition channels. They have to hold them a little bit longer. They sit vacant a little bit longer. Most states allow for non-judicial foreclosures. So in a non-judicial foreclosure, obviously, we're not going through the court system. And there's a statute, a deed of trust statute, that's codified in various state laws that allow for the granting of what's called a deed of trust. And in that scenario, the borrower doesn't grant a mortgage. They sign a promissory note in favor of the bank, and then they grant a deed of trust. And deeds of trust came about, really back in the 60s. There was a big movement for, the Uniform Deed of Trust Act. And it was a way for the lenders to provide a little bit of certainty when they foreclose on collateral to get it back. It provided some consistency. So you don't have the 1 year right of redemption period to wait. Once the trustee sale happens, then the new owner could essentially put it for sale right away to kind of minimize their losses. Yep. So the non-judicial foreclosure, there is no redemptive right, at least in Idaho. I can't speak for every state. But when the trustee's sale occurs, there's things that the trustee of the deed of trust has to do. So when a default occurs, the beneficiary or the lender elects to go ahead and declare a default, and you record what's called a notice of default, putting not only the borrower but also all junior lien holders on notice of the fact that there is a default. And then it's a statutory process. You have to post the property, you have to do some certified mailings, you do all the things that really equates to due process. You just let whatever state you're in, you're going to have to follow their statutes on that. And the timing varies too. In Idaho, it's 120 days. In some states, it's 90. But the non-judicial process is really by advertisement and sale. So the trustee just advertises and notifies the public as well as any party with a recorded interest in the property of the sale. And then you hold, upon the passage of enough time, you hold your trustee sale. And that's where it's a public auction. But at trustee sale, the successful bidder obtains a trustee's deed. So title is conveyed at that point in time. Which is a big difference between a 1 year redemption period. Correct. Right? Yeah, there's no redemptive right in play. And so the bank that is foreclosing, or the investor, the third party purchaser that buys it at auction, is obtaining the property free and clear of any junior liens and encumbrances. And they have the ability to move into the property within a pretty short amount of time to take possession. On a personal level too, I'd say, I kind of went through the boom and the bust, and as a broker, it's really sad because a lot of times you're talking about where things didn't go well. Someone lost a job, or their income fell, or something happened where they couldn't afford the payment. So it can be extremely traumatic. And obviously during the Great Recession, we saw a lot of this throughout the country. And I think it kind of gave us an opportunity to look at the way that judicial foreclosure states handled these loans that weren't being paid, and judicial states like Florida. And I've heard a lot of just
horrific stories on all sides, both judicial and non-judicial, but would you say there's kind of a real resolution at some point, or a common consensus that one is preferable over the other at this point?
Well, I think it's a matter of perspective. If you talk to most banks, they probably prefer non-judicial states just because there is it's a statutorily driven process. So there's consistency in that, both from a timing standpoint as well as the outcome, right? If they bring it current, great, it stops. If they pay it off or get it sold in time, it stops. The judicial states, I think from a lender's perspective, they would say that it creates inconsistency because somebody can tie things up in court if they have, with the internet now, you just go online and find some forms and clog up the court system and delay the process. And I think it takes longer to get that property converted over to bank owned or investor owned and then put back into, productive use in society, where the borrowers aren't basically living there for free. Now, from a borrower standpoint, if I was somebody, I would argue that, maybe the judicial process gives me more due process rights because of the opportunity to appear in a lawsuit and defend and present defenses, whether they're valid or not. That's for a court to determine. So, again, it's a matter of perspective, but by and large, I think the deed of trust states or the non-judicial states, it makes real estate a little more fungible. I think banks have a little bit less of a concern lending in those states, having gone through the Great Recession and some of the hurdles they had to overcome through the judicial foreclosure process.
Yeah, very, very interesting topic. Gosh, I really appreciate having you here, Jesse. I think we're probably over our 30 minutes here, but
I enjoyed it. I appreciate being here.
Yeah, thanks a lot. And we'll put some of your information up on the website. So if you have information or if you have questions for Jesse, then we'll have your contact information so they can get up there and talk to you about 1031 exchange here in Idaho or California or whatever. So
you bet. My time is free. I'm like a public defender. So
an attorney whose time is free.
Yeah, happy to answer any 1031 related questions. I try to stay away from the domestic law issues.
Okay, good. Yeah, you may not want to tell them your time's free. I'm just within reason. So, well, thank you very much, Jesse, and we will talk to you later.
All right, it's a pleasure.
Thanks. Bye.
This has been another episode of Real Estate Insiders Radio. To hear all episodes featuring our handpicked real estate insiders, visit us online at realestateinsidersradio.com.